Hi everyone, in this lesson we'll be talking about courts and jurisdiction. So we're going to describe the federal and state court systems. We're going to compare jurisdiction of federal courts versus state courts. We're going to define standing to sue, jurisdiction, and venue, and we're going to explain how jurisdiction is applied to digital commerce. The major court systems in the United States are the federal court system and then the various state court systems. State courts resolve more than 95% of the lawsuits brought in this country. A very small minority actually go to the federal court system. And even then, most disputes are resolved out of court before they even get to a state or federal court. So probably 90% of lawsuits are settled or negotiated or something before they actually reach trial. Of the ones that reach trial, 95% would be heard in state courts, the remaining in federal court. So looking at state court systems, there are several kinds of courts. One is a general jurisdiction trial court. They hear most types of cases. They will hear testimony and evidence. They will eventually reach the decision. Some states have different courts for criminal versus civil trials. North Carolina, they operate basically out of the same system. The decisions are appealable to an intermediate appellate court or the state Supreme Court. Outside of the general jurisdiction courts, we have some limited jurisdiction trial courts. They'll specialize in specific types of topics and types of cases. An example could be small claims court, where we're looking at cases involving small dollar amounts. In North Carolina, there aren't as many state limited jurisdiction trial courts. Most of them operate out of our district court system. But other state courts do. And the federal court system has a lot of limited jurisdiction trial courts. If, let's say in a trial court, one party is not satisfied with the decision that is reached, they can appeal, and it would go up to an appellate court. They hear appeals from trial courts. They review the trial court record to determine if errors of law have occurred during trial that require either reversal or modification of the decision. We're not retrying the case. We're not bringing in witnesses and hearing testimony again. We're not reviewing everything, really. We're just looking at the court record to see if mistakes were made for which the appellate court needs to make some kind of correction. If you're not happy with the appellate court decision, you can try to appeal to the state Supreme Court. So, in North Carolina, we call it the state Supreme Court. Most other states also call it the state Supreme Court. They hear the appeals from intermediate appellate state courts and some trial courts. Some kinds of cases will go directly to Supreme Court. We'll cover that a little bit later. Again, no new testimony or evidence is heard. We're just reviewing the records from the trial court and the appellate court to see if any change needs to be made. The decisions of state Supreme Courts are final unless there's an error related to federal law. Then we can try to go into the federal court system. Getting your case heard by the United States Supreme Court is extremely rare. But it is a possibility, especially if there is some kind of federal question involved. Death penalty cases involving U.S. constitutional issues are often the kinds of cases that are appealed to the Supreme Court of the United States, abbreviated here as SCOTUS. Just since there is constitutional protection against cruel and unusual punishment, a lot of times we see death penalty cases appealed to the Supreme Court. It doesn't always happen, but it's fairly common. So if we're to look at a typical state court system, what we would see is at the lower levels, we have small claims, some municipal courts, justice of the peace courts usually have magistrates in these courts who are making decisions. One level above that, we have some states have, again, different divisions for civil versus criminal, probate, like family court, juvenile court, in which these would all, the general jurisdiction courts would then flow up to the appeals courts and then up to the state Supreme Court. And then your only remedy outside of that might be the United States Supreme Court. But let's look at North Carolina more specifically. This is a little bit more complex here, but the basic structure is still the same. We have an administrative office down here. We have magistrates who will hear small claims cases. If you appeal out of small claims court, it can go up to a district court, which would hear some types of felony cases, civil cases that are $10,000 or less. We can appeal then either to the appellate court, or it can go to Superior Court, which hears all types of felony cases, and then civil cases that are higher than $10,000. You can read through a lot of the details here, but a lot of administrative agencies also go, if there's a dispute, then that goes to Superior Court as well. From there, either the District Court or the Superior Court, we would appeal most likely to the Court of Appeals, unless there's some specific circumstances that would allow us to go directly to the Supreme Court. But normally we'd go Superior Court to Court of Appeals, then to the Supreme Court, and then you're probably done at that point unless you can somehow convince the United States Supreme Court to hear that case. Even getting to the state Supreme Court is quite rare. So that was a state court system. Let's talk about the federal court system a little bit here. So there are multiple limited jurisdiction courts in the federal system, like the tax court, Court of Federal Claims, international trade, bankruptcy, Court of Appeals for the Armed Forces, Court of Appeals for veterans claims, that all hear just those specific types of cases. There are also the general jurisdiction courts we call U.S. district courts. The country is basically sliced up into a lot of different districts that we'll look at on a map in a little bit. And within each district, there will be a number of courts, as well as an appellate court, and then, of course, the United States Supreme Court. So the trial courts, the general jurisdiction courts, they impanel juries, receive evidence, hear testimony, they decide cases. And then if you're not happy with that decision, you can try to go to a United States Court of Appeals. Those are the intermediate appellate courts, one level below the United States Supreme Court. They hear those appeals. Again, we're not hearing new evidence. We're not hearing testimony. Again, we're just reviewing those court documents. The attorneys will go and make their arguments for why a modification either does or does not need to be made. And then the appeals court will make their decision. There are 13 circuits in the United States, and here's a visual of how those circuits work. So if we're looking at our circuit here in North Carolina, we're in the 4th Circuit, along with South Carolina, Virginia, West Virginia, Maryland. One little artifact of how the United States work is that Washington, D.C., even though it's in here in Maryland, has its own circuit. There's also a separate federal circuit that hears specific types of cases. So, DC isn't included in our circuit, but, North Carolina, South Carolina, Virginia, West Virginia, Maryland, all in the 4th District here. We have district court in Charlotte. If we were to try to go to an appellate court in our district, that would be in Richmond, Virginia. So U.S. Courts of Appeal, again, they review that record of the lower courts or the administrative agencies. They determine if there's been any kind of error that needs reversal or modification. Sometimes an appellate court will just affirm a lower court's decision and then nothing changes. Sometimes they will say that the lower court erred, and then they'll kick it back to the lower court to say you need to make another decision in light of this new modification that we've made. Sometimes they just completely overturn a decision, and then that undoes what the lower court did. Usually going to be heard by a 3-judge panel. You can request an en banc review, meaning getting all the judges in that circuit, somewhere between 9 and 12 usually, to hear that case. They may or may not take you up on that request. Then, of course, the Supreme Court of the United States, we hear about this all the time, just because it makes popular media all the time, especially when we're considering either bringing on a new justice to the court or a particularly popular case that's going to be heard by the Supreme Court. The Supreme Court can receive cases from multiple sources: the Federal Circuit Courts of Appeals, the Federal District Courts, Special Federal Courts, State Supreme Courts. Again, with all these appellate courts, no new evidence or testimony is heard. And then the Supreme Court's decision is final. You don't really have any avenue to appeal higher than the United States Supreme Court. You could, I suppose, try to go to some kind of international body, but even if you did, the United States probably isn't going to recognize any other court's decision outside of our own system. So the Supreme Court is composed of 9 justices. Those justices from time to time are nominated by the president. They have to be confirmed by the Senate. There's been several of these lately that have made the news media and caused quite a stir. It's always pretty controversial because people are watching the balance of the Supreme Court, whether it be conservative versus liberal or whatever, just to see what kind of decisions they might make. So if you're supporting certain policy agendas, you might be very concerned about the makeup of the Supreme Court to see if, if you pass a law and if it gets challenged, will the Supreme Court uphold that or not? So it's very consequential, very important, and that's why it can get quite controversial. So every time we have an election, the president's going to appoint one justice as the Chief Justice of the Supreme Court. The other 8 are referred to as associate justices. So it operates much like an appellate court. Other than that, it's just the highest one in the land. Okay, so the U.S. Supreme Court can make different kinds of decisions that will have different consequences. One is unanimous decision, where everybody on the Supreme Court agrees on the outcome and the reasoning used to achieve that outcome. Once we make that decision, that serves as precedent for later cases that have similar circumstances. We try to be consistent. A majority opinion means a majority of the justices agree on the outcome and the reasoning. That, again, will serve as precedent for later cases. A plurality vote means that the majority of justices agree on the outcome, but not on the reasoning. And so since we would have differing reasonings there, it would not serve as precedent. So what happens a lot of times in these cases is we have a majority decision, and then we might have one decision written down, and then another justice could write a concurring opinion and then write their reasoning down. And so that case is resolved, but it doesn't serve as precedent for later cases. And then finally, in rare instances, and this happened recently a couple times, we could have a tie vote where either one justice has to recuse themselves because they were too involved or knew some of the people involved in the case, or as with what happened recently with the Supreme Court within the last couple of years, Justice Antonin Scalia passed away, and so we only had 8 justices on the court until we could get another one on. So if you have a tie vote 4-4, then whatever the lower court decided, that decision stands, and then no precedent is set there. A little bit of vocabulary associated with the Supreme Court. If I'm going to try to get them to hear my case, I would petition the court for a writ of certiorari. It's just a Latin phrase trying to get documents transferred. So I petition them for that writ. If they decide to hear the case, they would actually issue that writ of certiorari. They'll give notice to the lower court to transmit all the documents up to the Supreme Court for review. A couple other vocabulary words. Like I said earlier, with a plurality decision, oftentimes we have a concurring opinion written by a justice who agrees with the outcome of a case, but not necessarily the reasons why we reached that outcome. We could also have sometimes justices who disagree with the majority opinion will write a dissenting opinion explaining why they don't agree with the decision, why they think the majority was wrong, and explaining their reason in that dissent. It doesn't have any legal weight necessarily because they didn't win the vote, but it can be informative to understand why certain justices think certain ways about certain cases. A little bit of a visual on the federal court system. So we have lower level courts here. So if we were to start over here with U.S. bankruptcy courts, which would flow into the U.S. district courts, which would flow up into U.S. courts of appeals, which would then flow up into the United States Supreme Court. But you'll also notice that there are lots of other types of limited jurisdiction courts that also have their own system. So the U.S. Courts of Appeals for the Armed Forces has its own little branch here that come from appellate courts of military services. The U.S. Court of Appeals for the Federal Circuit hears specific types of cases like international trade, patent and trademarks, veterans claims, U.S. Court of Federal Claims. So it's kind of complex, but the general structure is the same. Lower level courts flow up to appellate courts, flow up to Supreme Court. So what types of cases might land in the federal court system as opposed to the state court? Again, most cases are heard in state courts, and even then most cases are settled before we even get to court. But if we're going to find ourselves in court, it's good to at least have some understanding of the general structure. So the types of things that can land a case in federal court are cases that involve a federal question. So this could be a constitutional issue for the United States Constitution, could be a federal statute that we're dealing with here, a federal regulation that we're dealing with. There's no dollar amount requirement on the types of cases if it involves a federal question. Another type of case that could land in federal court involves diversity of citizenship, meaning we have citizens of different states or a citizen of a state and a citizen of a foreign country. So in order for a diversity of citizenship case to land in federal court, the amount in controversy has to exceed at least $75,000. So federal courts do have exclusive jurisdiction, meaning they're the only courts that can hear cases involving certain things like federal crimes, antitrust cases, bankruptcy cases, patent copyright issues, and then if somebody's trying to bring a lawsuit against the United States. They also will hear most admiralty cases. Admiralty law is also known as maritime law. It's basically dealing with navigable waters like oceans and lakes and rivers, if we have, usually involving shipping and commerce for the most part. So what jurisdiction do state courts have then? So the easy answer is everything that federal courts don't have the jurisdiction for. The state courts that would fall under their jurisdiction. Sometimes we have cases where either a state or federal court could hear it, and we would call that concurrent jurisdiction. Those cases involving, for instance, the diversity of citizenship. If there was a federal question that the federal courts did not claim exclusive jurisdiction over, we could also have concurrent jurisdiction there. Generally, the defendant would decide which court would hear a concurrent jurisdiction case. If we have the option of going either to state or federal court, the defendant would have the decision there. When deciding whether to stay in state versus federal court, you would probably just have to have a conversation with your attorney to try to figure out, which system do you think you'll get the fairest trial? Which system do you think you have the best case of winning in? The federal system is going to be slower and more expensive, but if you think you have a better chance of winning there, maybe it's worth it. So the full faith and credit clause of the United States Constitution says that a judgment of one court of one state must give full faith and credit to the courts of another state. So if one court in one state makes a decision, then other courts in other states should give full faith and credit. So what does that mean? Well, I'll give you an example of a case called VL versus EL. This happened in 2016. It went to the Supreme Court of the United States, and it had to do with a decision in Georgia that was the people were asking a court in Alabama to recognize a decision that was made in Georgia. So the facts of the case. VL and EL were two women who were in a relationship from 1995 to 2011. EL, through in vitro fertilization, gave birth to 3 children whom VL later decided to adopt. They went to a Georgia court that made the adoption official. So now VL is considered to be a legal parent to the 3 children. They later moved to Alabama from Georgia and then later separated. A custody dispute arose between the two, with VL claiming that EL was interfering with her ability to see the children. VL filed a lawsuit for the state court in Alabama to register the Georgia court adoption decision and award visitation or custody, which it does. But then it goes to an appeal court and finds its way all the way to the Supreme Court, with the Alabama Supreme Court saying it does not have to enforce the Georgia adoption judgment. Apparently in Alabama, they didn't look too favorably upon same-sex partners having parental rights. So VL appeals to the United States Supreme Court. The United States Supreme Court said that the full faith and credit clause required Alabama to recognize that Georgia court decision, and they remanded it back to the lower court to decide custody or visitation rights. So you see, the decision that was made in Georgia, according to United States constitutional principles, had to be recognized and given full faith and credit in Alabama. So a little bit more vocabulary here. Standing to sue means that the plaintiff must have some kind of stake in the outcome of the case. If I can establish standing to sue, then I have a right to bring a lawsuit. If I cannot establish that I have standing to sue, then I will not be allowed to bring that lawsuit. So usually means that I was a person that was injured in some way. That's kind of how it shakes out usually. In personam, or personal jurisdiction, is the court's jurisdiction over a person. So there's different kinds of jurisdiction. Jurisdiction is just the ability to apply the law, either to a geographic area or to a person or over some property. So here we're talking about jurisdiction over a person. So the court always has jurisdiction over the plaintiff because the plaintiff is the one that brought the lawsuit in the first place. Now we have to determine whether the court has it for the defendant. So in order to establish if we have jurisdiction over the defendant, we have to look at, did the act happen in that jurisdiction? If we're looking at a Georgia court, did some criminal act happen in Georgia, or did some civil offense actually happen in Georgia? If so, it'll be easy to establish jurisdiction over that person. Does the defendant live in the jurisdiction? Again, it would be easy to establish jurisdiction that way, where they serve process in the jurisdiction. And then each state will have its own long-arm statutes sort of spelling out in which cases they have jurisdiction over people. But the basic idea is that if the incident happened in that jurisdiction, they have the right to bring them in, or if the person lives in that jurisdiction, then again. Service of process just describes serving a summons on a person. A plaintiff files a complaint. Court would serve summons on the defendant, establishing jurisdiction, calling them in to court. So again, personal jurisdiction exists over a defendant who's within the boundaries of that state if we're dealing with that state's courts. A corporation is subject to personal jurisdiction in the state where it is incorporated, in where it has a principal office, or where it does business. So when trying to establish jurisdiction over a business, we might find that there's a business that's operating in North Carolina, but it's based in California, and maybe it has its principal offices up in Delaware or something like that. And then trying to decide whether or not we can actually bring a lawsuit against that business. It might be incorporated in another state, so maybe we can't establish it that way. It might have principal offices in another state, but if it's doing business in North Carolina, then we can establish that jurisdiction over them and bring them in for the lawsuit. A long arm statute, like I described a little bit earlier, are statutes that states will pass that will spell out the boundaries within which we can establish jurisdiction over a person who doesn't live within that state. Even though each state gets to write their own long arm statutes, they still have to satisfy due process concerns in line with U.S. constitutional principles. That was brought up in the case International Shoe Company versus State of Washington. This was a shoe company that was based in Delaware but had principal offices in Missouri. And they had sent a salesperson to the state of Washington who did door-to-door sales and generally conducted, business there. So when the state of Washington assessed an unemployment tax on the International Shoe Company, there was a dispute where the shoe company was saying that they didn't have any jurisdiction to sue them or to assess that tax. So then the court had to try to figure out, at what point do we establish jurisdiction over a company. And they came up with this minimum contacts decision, saying that if a business has minimal business contacts, we're doing business, we're selling to people in that state, then they're probably going to be able to enforce that long arm statute. So it doesn't happen everywhere, and every little de minimis amount of business isn't always going to qualify. But it doesn't really take that much to establish jurisdiction if you're doing some type of business in another state. States generally permit jurisdiction over non-residents in the following situations. One, the defendant committed a tort within that state. The defendant entered into a contract either in that state or a contract that affects that state in some way. And the defendant transacted other kinds of business in this state. So that's generally the kind of things that allow us to establish jurisdiction over a non-resident. In rem jurisdiction is jurisdiction established over some property of a lawsuit. Okay, so it might be like real estate property that's located in some geographic area. That would be in rem jurisdiction. Quasi in rem jurisdiction happens sometimes when we have some kind of dispute involving crossing state lines. Maybe somebody that lives in another state came to North Carolina and stole some of my money or something. And then I'm going to try to go after him to recover that. And so I might obtain a judgment in North Carolina entitling me to recover money from that defendant. But they're not here. They live in another state. So I might go to that state they live in. Let's say they're in Virginia. I might go to a Virginia court and say, hey, I have this judgment from North Carolina. I need to attach this to the defendant's property. And maybe I can attach it to the real estate that they own there to try to recover my money. Venue is how we describe where a case is going to be heard. So general rule is that a lawsuit has to be heard by the court in the jurisdiction where the incident occurred or where the parties reside. That's going to be the case most of the time, almost all of the time. It will happen in the court in that jurisdiction geographically or wherever the parties reside. There are special circumstances sometimes where people might try to get that venue changed. Maybe they don't think they're going to get a fair trial where they live or where the incident occurred. Or maybe it could be because a lot of publicity. Sometimes we have these celebrity trials where they try to get a change of venue because the news media in that jurisdiction has just been so crazy that it's hard to find jurors that aren't already biased by the stories that have come out. So it can happen. If I think I'm just not going to get a fair trial for these reasons, we can try to get a change of venue to see if we can get a more favorable decision somewhere else. Some businesses have latched on to change of venue for some specific types of case involving copyright and stuff like that. It's a little bit beyond the scope of this class, but it can happen sometimes. They call it venue shopping or forum shopping to try to find a jurisdiction that would be more likely to give me a favorable decision. So getting into the actual business law side of things here, looking at forum selection and choice of law. So these are kinds of things that will be handled in a contract. So a good portion of this class will be dealing with contracts, the elements and clauses and stuff like that. So in a lot of contracts, what we'll see are forum selection clauses and choice of law clauses. So a forum selection clause says that, okay, if we're going to do business together, if there is a dispute, we're going to select this specific forum, call it North Carolina District Court or something like that, as the forum to hash out that dispute. And that would be selecting our forum in the contract. If both parties agree to it, then it's fine. Similarly, a choice of law clause would choose which rules we're going to follow. So, okay, again, if we're doing business across state lines, we might have different state laws that treat this kind of business a little bit differently. So we agree ahead of time and say, okay, we're going to apply the Uniform Commercial Code as adopted by the state of North Carolina, something to that effect. And so if we choose both of these things, then we've gotten some of the major issues out of the way if there's a dispute later, saying, hey, we're going to apply North Carolina law. We're going to have it heard in North Carolina courts. That way, everybody knows that they're playing. It's important just to know what kind of rules we're playing by here. A case that dealt with a forum selection clause was Carters of New Bedford versus Nike, involving a forum selection clause in a contract. So the facts are this. Nike's headquarters is in Beaverton, Oregon. Carters of New Bedford operates 2 stores in Massachusetts and has sold Nike products for 28 years. Their contract was included in the invoice agreements that the parties signed. The invoice agreement contained a forum selection clause requiring claims that Carter's had to be brought to court in Oregon. Nike later notifies Carter's it's going to terminate the parties' business relationship. Carter's wants to sue for breach of contract, and they bring the case in Massachusetts court, but Nike goes and argues that Massachusetts court can't hear it because they had signed this contract, saying that any case would have to be moved to Oregon court. Carter's is obviously not going to be in favor of this because having to travel from Massachusetts all the way across the country to Oregon, they say would be a heavy burden on them and would make it impossible for them to bring the case. But Nike's going to say that, hey, you agreed to this when you signed those invoice agreements. So the question here being, is the forum selection clause enforceable? So the reasoning of the court was that Carter's failed to persuade the court that they would face extreme hardship if forced to go to Oregon, which, according to their argument, would make it practically impossible to litigate. But the court didn't really buy their argument, so the court did enforce that forum selection clause. Now, thinking about the case, if we look at a lot of major corporate terms of service and contracts, we're going to have these forum selection clauses and choice of law clauses in there. So if we're to think from a business strategy perspective, why would Nike have this clause in their contract? Well, many reasons. One is that it's important to know what rules you're playing by. It's important to know what jurisdiction the case is going to be heard in. For Nike, it could also be a matter of convenience, having the lawsuit happen in the state where they're based rather than having to travel across the country. The flip side of that is Carter's is a lot smaller and they face a heavier burden having to try to travel across the country. Modern technology has made it a little bit easier. We can remote in to court and hear arguments. We're seeing a lot of this happen during this COVID crisis, where people are just zooming in and giving testimony, or attorneys giving their arguments that way. But before, when this happened, that wasn't as big of a deal, so they actually had to physically travel to try to bring that lawsuit. Another question, will small retailers be able to pursue claims in Oregon? It's going to be hard just because, again, you face that the time and money aspect of having to actually go out to Oregon. You also face the possibility that Oregon courts are going to be biased toward Nike because Nike is a huge contributor to the economy out there, and maybe you just don't think you're going to get a fair decision. So, yeah, for Nike, it's strategically a very good decision. It's going to reduce the amount of people that are going to sue them just because they don't want to travel. It's also going to, in their minds at least, give them more favorable decisions. As to whether or not it's ethical for them to do that, I don't know. Everybody can form their own opinion on that. The last thing we talk about is jurisdiction in cyberspace. So the rise of the internet, of course, and digital commerce has made us sort of try to figure out how to apply some old laws to some new technology. And, you know, for the most, there's glitches here and there, but for the most part, I think we've done a pretty good job. It was hashed out in one famous case called Zippo Manufacturing versus Zippo.com Incorporated. The basic facts were Zippo Manufacturing Company is the one that makes the lighters that everybody's familiar with. Zippo.com was a company that just bought the name Zippo.com and then started selling pornography on the site. So, you know, they were sort of capitalizing on the famous trademarked name in order to make money for themselves. Zippo Manufacturing was not happy with this, and they were trying to get Zippo.com shut down. But in you know, as the case was proceeding, what happened was that the court established some pretty important guidelines for when a court can establish jurisdiction over the owner or operator of a website. And they basically broke it down into three categories. One is an interactive website where people are actively doing business with other people on the internet. It's going to be pretty easy for a court to establish jurisdiction over the owner or operator. You know, I can establish a website, have the servers, I can live in North Carolina, but if I'm broadcasting out to every state in the United States or even over the entire world, if I'm doing business in that jurisdiction, there's the chance that somebody who bought my stuff out in the state of Washington or the state of California is going to be able to establish jurisdiction over me and try to bring me in for a lawsuit. The opposite end of that is a passive website where all I'm doing is just posting information out there for people to go read or download or whatever. I'm not soliciting business from them. They're not posting on my website. It's going to be very hard to establish jurisdiction in that case, having that passive website. And then there's everything in between, what the court called the semi-interactive website, where it's everything in between. So, you know, maybe people aren't giving me money directly, but maybe they're posting videos and their own content on my website, where we have this exchange, this interaction between the website and the people. So whether or not we can establish jurisdiction is going to depend on the facts of the case, the specific circumstances. But we'll have to examine the level of interactivity, the level of commercial nature of the information exchange to try to establish whether or not a court has jurisdiction over a person in that case. And, you know, a lot of this is still being hashed out. Every time we hear a case, you know, it'll depend on the circumstances there. So, yeah, I expect we'll see a lot more development on this topic in the future. So something businesses can do to try to protect themselves from lawsuits is to have those the forum selection and choice of law clauses in the terms of service for using the website. You know, saying that if there's a dispute, you have to bring it in this specific court, and we're going to apply these specific rules. And that might be something that can limit the amount of lawsuits you might face. It's not going to protect you against a criminal case, but it can protect you against a bunch of civil cases if somebody's just trying to sue you and you think they have a frivolous claim, or just trying to make money. But that wraps up this lesson. Have a great day.